Right, you are now going to have, buckle up, a crash course in New Zealand copyright. Okay? And we're going to go through, and I could have split this between 20 slides, but I decided I would just put this all on one slide so that you can learn, memorize, maybe I'll send you all a screenshot of it, the absolute key facts that you need to know to understand New Zealand copyright law all in one place. Now, there's also a handout which summarizes these things, which I've sent to you all as an email about 20 minutes ago. So unless you registered at the very last minute, you should all have a handout with that information too. But let's go through it. So Copyright Act 1994, New Zealand. Okay, first thing is copyright happens automatically. You don't need to register a copyright. You don't need to use a special symbol, like the copyright symbol, to make your work copyrighted. It's granted to you these days, did not always used to be the case, but certainly today, since the 90s, copyright's automatic for creative works. Right, what is a creative work? Well, you have to have created something with a sort of minimum threshold of creativity. Something that's generated automatically. Slapping a photograph on a scanner and pressing scan is not considered an act of creativity. It's just duplication. But if you took that photograph and tweaked it and cropped it and adjusted it and cleaned up the problems with it and maybe put a new color cast on it, maybe modified it a little bit, you're starting to approach a threshold of creativity where you can distinguish your creative work. Now, famously, one of the copyright people I know says that if you do a scribbly doodle on the pad beside the phone, congratulations, you've created a copyrighted work. And so the bar of creativity is actually quite low, purposely set that by the big companies who are very, very much like copyright. So pretty much any creative work, that's something you write, something you record or film, a photograph you take with your phone, is a copyrighted work. So we are all creating copyrights every day. Every email we write, every photo we take with our phone is a new copyrighted work, copyrighted to us. This did not used to be the case. People in the olden days did not make a lot of creative work, and you were a very specialized person if you created something that was protected by copyright law, a professional writer or an artist. But today, we're all copyright creators. Oh, there's a chainsaw going on in the background. This is going to be fun. Okay, so copyright's automatic. Everything you make is copyrighted. It's copyrighted to you, and it's protected by the full force of copyright law, which seems somewhat overkill, but that's the case. Now, copyrights do expire. They don't last forever. They used to last for 28 years, for example, and gradually, in the 100, 200 years ago, and gradually that term has been increasing and increasing. It never goes backwards. It always gets longer and longer. Currently, under New Zealand law, your copyrights expire 50 years after your death. And that continues if you move the copyright, you hand it over to someone else or pass it on, it's still going to expire. That 50 years after death is actually a little bit low now on international standards. Most Western countries have gradually inched it up to 70 years after death. And as a result of a couple of trade deals that were recently signed, New Zealand is now going to synchronize, is going to match those other countries. This was actually tremendously controversial. None of the creative sector who would be affected by this were consulted in this choice. It was just handed over as part of the EU agricultural trade agreement as a sort of bauble to help sweeten the deal. And now we have to rewrite New Zealand copyright law very quickly to synchronize with that term. But anyway, 50 years after death, though, is still a very long time. So if someone wrote a poem in their teens in 1925 and they're still alive today, which is entirely possible, then their work is still going to be protected for another 50 to 70 years, which is like 150 years after they did the creative work, which is an extraordinarily long amount of time. And we're constantly coming across cases where a work that we thought was out of copyright is still actually within the 50-year window after someone's death. Because of that, if we want to reuse that creative work, if we need to get permission to reuse that work, we need to find who the current copyright holder is. Obviously, it's not the person who's died because they're dead. So it's passed on to someone else. Whoever has inherited that person's property has inherited their copyrights, usually. Copyrights are almost never specified in a will. Copyright law is really actually set up for the benefit of large companies, multinational corporations. It's not actually very sensible when you look at it from the point of view of an individual, and yet here we are all creating copyrights. So this creates real problems where we have a work that was created by someone who died 30 or 40 years ago. It's impossible to find who the copyright holder might be now. They could have died with no known descendants, yet someone still owns that copyright. God knows who, and that work is called an orphaned work. And that is a real problem. If you're dealing with a lot of historical objects, then the problem of orphaned works is really noticeable, because even particularly in America, where the copyright terms are even more onerous, you can have work that essentially is unshareable or unreproducible or unusable by anyone for 50 or 60 or 70 years, because it's not clear who it is we could even ask for permission. And yet it is still protected by the full force of copyright law. So we do have a provision in New Zealand's copyright law that photographs that at the time of the law was signed, work that was taken over 50 years ago was deemed as out of copyright, and that work was signed in 1994. So anything taken before 1943 is definitely out of copyright in New Zealand. So that's photographs here. So if we look below, we'll see that the 1948 photo by Ron Blackmore, I got the date wrong, sorry about that, was copyrighted to Lincoln University. Why it's taken by Ron Blackmore, but Ron Blackmore was an employee of the university. So he is not actually the copyright owner, it's copyrighted to Lincoln. But Ron Blackmore did not die that long ago, and so his work is still in copyright, and even if Lincoln is the copyright owner. But another photo that he took in 1934, the copyright has expired because of New Zealand copyright law. So the pre-1943 ones, the copyright has expired. The way we technically credit that is we say no known copyright, and that as far as we know, this is uncopyrighted. It's a very weaselly way of saying yes, the copyright has definitely expired. It's very hard to think of a circumstance in which that could possibly be in copyright, but the institutions tend to just say no known copyright. If you see that, that means you are free to reuse that photograph for any purpose you like, commercial or non-commercial. You're not even required to credit the photographer. You can do whatever you like with it. Its copyright has expired. So that is luckily a situation for works taken before 1943, but in the USA, for example, there's no such nice provision, and in fact they're only just dealing with work that's from 1928 that's come out of copyright, because their effective copyright term is much, much longer than ours. Now, another thing that's different between New Zealand and the USA is in the US there's a concept of fair use. And this is why I said looking for copyright information on the internet is a bad idea, because you'll get someone talking about, oh, this is you reusing this under fair use. That's a specific provision in United States copyright law. What fair use means is that, yeah, you can reuse this, mostly if it's not completely cut and dried, but if you're not doing it for commercial purposes and you're not doing it in a way that's going to leech away the rights from someone else, and maybe you're just using a low resolution copy of it and you're not making lots of copies and so forth. There are a bunch of different qualifiers that if you tick most of those, what you do is considered to be fair use, and thus you're exempt from the usual copyright statutes. There is no such provision in New Zealand. There is a fair dealing provision which mostly applies to places like libraries and archives, and allows for the reproduction of certain portions, certain works for certain purposes, or certain portions of works for teaching purposes, and agreements that are worked out with those teaching institutions and libraries. But that is not something that applies to most of us in our daily lives. So we don't actually have an ordinary fair use provision in New Zealand. And what that means that even things like parody, for example, if you were to do a satirical song about a politician, we don't have any copyright exemptions for parody in New Zealand, so the copyright owners of that song could request that you take it down. So we have some problems with our copyright law in New Zealand, and that's the supposed incentive for reform of our Copyright Act. But just bear in mind that reusing a work, whether for commercial or non-commercial purposes, it doesn't matter in New Zealand. You will still have to pay attention to copyright. You can't say, oh, we're a non-profit. Oh, we're not making any money for this. Oh, it's a good cause. Oh, I'm only making a few copies. The only exemptions we have are actually for personal, private research or education. So making copies of things just for your own use and not sharing them with someone else is considered okay under the Copyright Act. But as soon as you start sharing copies with other people, you don't have any of that protection. And another interesting thing is the difference between owning a physical work and owning the right to make copies of it. So if you bought a Colin McCann painting or something, or indeed a creative work by any artist whatsoever, a photograph, a sculpture, a print, even a hand sketch or a doodle, and framed it and put it on your wall, you've purchased the work, the physical work from that artist, but you haven't probably purchased their copyrights from them. That would be quite unusual. Most institutions that own paintings, professional art galleries, when they purchase the painting, they usually did not purchase that copyright from the artist. The National Museum of New Zealand did act. The National Art Gallery did for a while in the 60s, which unusually, but most institutions, if you own a work, a physical work, it doesn't mean you own the copyright. So if you tried to make a postcard of that Colin McCann painting on your wall or a t-shirt, you would actually have to apply for permission to do that from the copyright holder, which is not Colin McCann because he's dead. It's the Colin McCann estate. The Colin McCann estate would probably want you to pay them a large sum of money because they're quite protective about McCann's copyrights, and it's a good income source for them. So just the ownership of a photo doesn't mean you own the copyright. How does this affect us? So a photograph of you, for example, you don't own the copyright of that photograph of you unless it was a selfie, because you did not push the button on the camera, and thus you did not make the creative act. The photograph was probably taken by someone else, and that makes them the copyright owner. So even if it's a photo of you, even if you own the photograph, even if you own the only print ever made of that photograph, you're not the copyright owner. And so if you wanted to reproduce that, put it online, even use it in a PowerPoint show, you would need to get their permission. And this is something that trips people up all the time in New Zealand, because we have another issue here, is that if work is commissioned or made on the job, just like the Ron Blackmore photograph below, just because Ron Blackmore pushed the button on the camera, that doesn't make Ron Blackmore the copyright owner. The employer, Lincoln University, owns the copyright. And this is a big issue particularly for large collaborative science projects, where you're trying to share graphs, charts, maps, or photographs of your work. Who actually is the copyright owner of those? You can come to the end of a very large science project and have a whole bunch of photography that you want to share in a paper or in a public talk, and you have to try and figure out who actually took those photos, and were they doing it in the course of employment, and what does their contract say? Who is their institution the copyright owner, or were they the copyright owner? Was it taken in their free time in the weekend? Was a professional photographer brought in to take those photographs? What does the professional photographer's contract say? Because despite point 6 here, most professional photographers in New Zealand put a clause in the contract, in the paperwork that you have to sign, that says they will retain the copyright of all the photos they take, despite what the Copyright Act says. And they're entirely able to do that. But what that means is that if you want 20 years later to publish that photo in a book or a report, you have to track down that photographer and get their permission. And possibly, if they're awful, you'd have to pay them again. So wedding photographers love to do this because they want to be able to charge for the wedding photographs multiple times, again and again, to different people. So I would recommend, my advice to you is if you engage in a contract with a professional photographer, check the contract fine print and see if you can negotiate to keep the copyright of the work that they do that you're paying for. That may not be, and generally photographers' professional associations advise them and even give them draft contracts to say that, no, here's what you need to put in your contract to keep your copyrights. You need to negotiate with them about that. If they refuse to budge, consider finding a different photographer, because the long-term usability of the photos that are taken are probably far more important than the creativity of any individual photographer. It's no use having wonderful photos if you can't actually ever reuse them again. So that's the 6 points. That is now a crash course in New Zealand copyright. All of these are important to consider if you are a practicing researcher dealing with any creative work. And that can be not just a photograph, but a diagram or a graph that you make, any piece of text that you write, whether it's a press release or an email or a passage in a scientific paper. Someone is a copyright owner of all of that work.